Hello, everyone. Welcome to another live edition of Employment Law Q&A. My name is Alex Lucifero. I am the managing partner of Samfiru Tumarkin LLP's Ottawa office, employment lawyer extraordinaire, here to take any and all questions related to the workplace, related to employment law. If you are an employee and you are struggling at work for one reason or another, maybe your boss is treating you badly, or a colleague of yours is mistreating you. Maybe you've been let go from your job and you're not sure what to do. You've been offered a severance package, or perhaps you haven't been offered any severance at all. Or if you're dealing with any other issue as an employee at work, if you've been temporarily laid off, or if perhaps you're dealing with a vaccination policy at work, any questions related to your employment as an employee, please, for the next half hour, feel free to go ahead and ask your question online. You are speaking with someone who practices employment law pretty much exclusively. And so I don't know much about family law. Don't ask me about your separation or your divorce, but ask me about your workplace. Ask me about your employment law questions. And I promise I will be able to help. I will be able to give you the advice and the information that you need and get you pointed in the right direction when it comes to your employer. Alternatively, if you're an employer, if you're a business owner, and you're dealing with a difficult employee, you're not sure what to do, you're having problems at your place of business, feel free to ask away. We do assist employers as well, and employers oftentimes do need a bit of an education when it comes to employment law and how to treat their employees in particular circumstances. A couple of pieces of contact information that I always give out at the beginning of each and every Q&A segment. You see it right on the screen right now. Our website address to begin is employmentlawyer.ca. It's an excellent resource. Go ahead and visit our website. We've got a ton of articles, video postings, any issues, again, that you have under the sun when it comes to employment law. We will have a blog post or an article or a video about it, and it is the place to get started and get you, again, headed in the right direction when it comes to answering your employment law questions. You also have our contact information online. If you want to find a particular lawyer or a lawyer in a particular office, then please go ahead and visit our website. If you want to contact us directly, I will give you our email address that you can reach us at. The email address is help@employmentlawyer.ca. It's again help@employmentlawyer.ca. You see it on the screen right now. Go ahead and email us. Send us a quick summary of your situation. Give us the basics. I promise someone will respond to you. Someone will get back to you and put you in touch with one of our employment lawyers, or put you in touch with someone at the firm that can help you resolve your workplace problem. A couple of topics I wanted to get to today before we get into the questions. And again, everyone, please feel free to go ahead and ask your questions. That's what we're here for today. Just comment with your question, and I promise I will get to you as quickly as I possibly can. Before we get into the questions, one item out of the news that I wanted to talk about today that's come across my radar is making the headlines. There was an Amazon employee out of the US that was recently let go. And this employee claims that she was let go because she had long COVID and because she was required to take a medical leave of absence as a result of the symptoms that she was experiencing because of having contracted COVID. And I think it's an excellent opportunity to talk about a subject that I think is extremely important in the workplace. It ties in both employment law and disability insurance law, which is another area of law we also assist employees with and get very often questions about. And that is the issue of medical leaves of absence. Lots of employees come to us and have questions and concerns about when they should be taking medical leaves, what's required from an employee when they do take a medical leave of absence, what rights do they have when they are off on a leave for health reasons, what an employer can and can't do when an employee has taken a medical leave of absence. And the first thing I'll say with respect to employees taking medical leaves of absence is the following. In Ontario specifically, and this is actually generally true across Canada as well. If you're watching from any other province in Canada, or if you're watching internationally as well, out of the States or anywhere else for that matter, unfortunately, we cannot necessarily assist any international viewers. Certainly, if you are in British Columbia, Alberta, or Ontario, we can certainly assist. And I could speak to at least Ontario employment law in that our laws are very, very protective of employees who take medical leaves of absence. As an employer, you cannot punish an employee who has taken a medical leave of absence. You cannot treat them any differently because they have taken a medical leave of absence. Employees who either require accommodation for medical reasons in the workplace or who are off on medical leave have very strong protections at the law. And I'll give you a couple of examples of these kinds of protections, and a couple of them I just alluded to. Number one, an employee who takes a medical leave of absence cannot be fired for having taken that medical leave of absence. That is discrimination. It's contrary to the Human Rights Code in Ontario, and it is effectively illegal. An employer who terminates an employee because they took a medical leave of absence, as was alleged in this Amazon case that I was referring to earlier out of the States, that employer is going to have to pay damages for discrimination. They're also going to have to pay that employee severance. Again, you cannot terminate an employee because they took a medical leave of absence. That employee is effectively protected from a termination when they are on medical leave. Now, as a small caveat to that, I should probably add, an employer can potentially let an employee go who is on a medical leave, provided the reason for termination is entirely unrelated to the leave. So if you work as an administrative employee in an office, for example, and you are on medical leave, if the employer decides to restructure its operations and that particular office closes permanently, well, then that termination is legal, as long as, of course, the employee is owed severance, is paid severance. That employee can still be terminated because the reason for termination was not the fact that they are on medical leave, but simply because, again, the office closed and their position has been restructured. So there are exceptions to that rule when the reason for termination is entirely unrelated. But again, as a general principle, an employee cannot be terminated because exclusively they are on medical leave. Second example here, before I get to Liam's question, thank you for your question, Liam. I'll answer it in a sec. An employee, and again, I'm speaking here to the strong protections that employees have when it comes to medical issues in the workplace and medical leaves of absence. An employee who has a disability in the workplace, let's say they've been off on a leave and they've had some sort of surgery or they're recovering from some sort of condition, that employee is allowed to return back to work with some limitations, with some restrictions. And the employer is obligated to accommodate those disabilities, accommodate those medical restrictions. If an employee is not able to walk a certain distance or do a certain amount of work per day or lift a certain amount if they're working a physical job, provided that employee provides a doctor's note that explains all of these restrictions, the employer has to play ball. The employer cannot simply say, oh, well, if you have some restrictions, we're not having you back to work. You can just stay home and not earn any pay. Absolutely not. The employer has to have that employee return back to work with those restrictions, and the restrictions have to be accommodated. They have to be accommodated to the point, and this is the phrase that the law uses, to the point of undue hardship. What that effectively means is it has to be extremely difficult for the employer to accommodate those restrictions in order for the employer to reasonably say no. What that means is actually the accommodations have to be, or they are expected to be, actually somewhat difficult. They're expected to be somewhat difficult to accommodate an employee. That is expected. That is part of the name of the game. That's not good enough. Even if it's a little difficult for an employer, again, an employee's medical accommodations need to be accommodated, provided that the information is provided from their doctor, right? Provided you have a doctor's note that says clearly what you can and cannot do as an employee. You cannot be punished. You cannot be sent back home because you have medical restrictions in the workplace. I will pause right there. I wanted to get into a little bit more on this subject of medical leaves of absence in the workplace, but questions always take priorities. And as I mentioned, everyone, this is a live Q&A. Please feel free to ask your questions. Go ahead and post them in the comments, and I promise I will get to them, whether they're on YouTube or Facebook or any other site that you're seeing this on. Once again, my name is Alex Lucifero. I'm an employment lawyer with Samfiru Tumarkin LLP. I'm a partner with the firm, manage the firm's Ottawa office. If you're looking for some guidance when it comes to employment law, you've come to the right place. Again, go ahead and ask your question. I promise I will get to it. All right, first up for the questions today, Liam asks, I'm an older employee and part of the higher risk or high risk population. Can I be fired for refusing to return to the office? Excellent question, Liam. It's one that we often get, actually more and more nowadays, as employers are actually having employees return back to the office after COVID. Liam, if you have a doctor's note, if you have medical support and evidence that says that it is too dangerous for you to return back to a public space like an office, again, going back to the medical leaves of absence and accommodations that we were just discussing, your employer should be accommodating that request. Now, again, the request shouldn't come from you and you alone. You need your doctor's support. If you don't have your doctor's support, I think your situation becomes much more challenging. The reason why that is because if you've been working from home as a temporary measure all along due to COVID, your employer does have the right to recall you back to the office. So it is not unreasonable for an employer to ask employees to return back to the office if working from home or working remotely was always considered a temporary measure. If you're always working from home on a permanent basis, even before COVID, well, then that is a permanent term of employment, and you have the right to enforce that term and refuse the offer to return back to the office. But again, if the work from home arrangement was a temporary measure because of COVID, employers do have the right to recall you back to the office. The only way that you can combat that, Liam, in your situation, again, you mentioned being part of the high-risk population if you're older, is you need your doctor's support in effectively giving your employer a medical note that it says it is too dangerous for you to return back to the office. You should be accommodated by continuing to work from home. That is by far the best protection that you can have in making sure you get what you want. All right, next up, Melinda asks, how much medical information is an employer allowed to ask for? Great question, Melinda. And again, in line with our topic today, the short answer, Melinda, very little. Actually, an employer doesn't really have the right to know much about your medical status. They do not need to know what the diagnosis is. So they don't necessarily need to know what you're struggling with, what condition you have, or what the medical issue is. The only thing they do really have the right to know, Melinda, is what the prognosis is. What I mean by that is they do have the right to know how long you might be off for, what the potential recovery plan might be in terms of timeline for a recovery back to return back to work. And also, in the same respect, what restrictions you might have in being able to work or not. It's reasonable for an employer to ask those kinds of questions. So again, how long might you be off for? What's a reasonable expectation for a return to work plan? And if you are getting closer to a return to work, what can you do and what can't you do? All of that for an employer is fair game to ask. Anything beyond that, again, as far as particular diagnosis, particular treatment plans, that is effectively none of an employer's business because it doesn't impact their rights and obligations when it comes to the workplace. Again, what an employer should be asking about is how long the employee might be off for and what they cannot do in the workplace to try and figure out what accommodations they need to implement or not. If your employer is asking you to fill out a lengthy questionnaire, Melinda, about what exactly your condition is and asking your doctor to sign off on, allowing the employer access to medical information, that should be a red flag. And you should certainly be speaking with an employment lawyer if you're in a situation like that. Again, employers do not have the right to know a lot of what you are going through if you are on a medical leave of absence. All right, I love the questions, guys. Keep them coming through. We are about halfway through the segment now. Got another 15 minutes or so left. Once again, for those of you just tuning in, my name is Alex Lucifero. I'm an employment lawyer, partner with Samfiru, Tumarkin, LLP. This is a live employment law Q&A. If you are struggling with an issue at work, whatever the situation is, maybe you've been let go, maybe you're on a temporary layoff, maybe you're just dealing with a difficult colleague or a difficult employer, go ahead and ask your question. You don't have to provide any details. Just ask it in a very generic, general way. And I promise I will get to you and give you the information that you need. If you want to contact us privately, maybe you're a little shy, maybe you're a little bashful, you don't necessarily want to ask your question on an online forum, employmentlawyer.ca is where you can find our contact information. Again, we've got a ton of resources on the website. We also have all of our employer profiles and all the contact info for our various offices across Canada. And again, you can email us at help@employmentlawyer.ca. Give us a brief description of your situation. Email us, and I promise you someone will get back to you. Let's get back to the questions, everyone. Megan asks, my branch is being shut down and I'm being relocated almost an hour away. Can I resign and still get severance? Excellent question, Megan. What you're referring to here is what's called a constructive dismissal. A constructive dismissal occurs when there is a significant or a substantial, those are the words that the law uses, a significant or a substantial change to the terms of your employment. Megan, if your office is being shut down and you're having to relocate an hour away from, let's say, your current workplace or perhaps even where you live, listen, they may very well be a constructive dismissal. It likely is, actually, if it is indeed an hour away. An hour is probably an unreasonable, if it's an hour travel time, it is probably an unreasonable request on the part of your employer to ask you to move that far. Now, Megan, very important, the devil is in the detail, right? So I want to be very specific about exactly how far it is, the modes of transportation, how significant a change it is. That's what we have to discuss and weigh up. Do not resign right away. Do not talk to your employer about severance right away. You need to speak with us as soon as possible. Send us an email. Again, email address is help@employmentlawyer.ca, or again, find our contact information online and you can reach out to us directly. Let's chat about your matter. Let's dig into the details. I think there is certainly a claim here for severance if indeed you're having to relocate an hour from your current place of work. That likely would be a constructive dismissal. There have been numerous cases before where such a move has been found to be a constructive dismissal. So, Megan, before you say anything to your employer about any of this, before you sign anything, before you talk to them about severance, before you even reject the move, let's talk about strategy. Let's talk about what your severance entitlements are. Let's figure out, A, what options you have, right? Maybe there's a way to salvage the situation somehow. And then B, what your best option is. And then let's go ahead and proceed with that best option. And again, the way you do that, contact us, right? Send us an email, give us a call, get a hold of us, whichever way you want to. Let's have a chat about your matter. It's a great question, Megan, and I'm glad you asked it because there is something there to pursue, almost certainly. All right, Antonella on Facebook is up next. Thank you for your question, Antonella. My employer, she says that it is working with a medical consultant to monitor the circumstances surrounding COVID and plan on welcoming back unvaccinated employees in due course. Can I hold them accountable for making that statement that they are working on a plan to welcome unvaccinated employees back? I'm not sure what you mean by hold them accountable, Antonella, and perhaps what the angle is here that you're looking for. If you are a vaccinated employee who's been working in the office and you're maybe concerned about that, well, I'm not sure what options you might have there. Certainly, an employer still has to abide by all of its health and safety obligations, particularly when it comes to COVID-19. But again, perhaps you can clarify your question. I'm not sure how welcoming unvaccinated employees back into the office might impact you in that respect. On the other hand, if you are an unvaccinated employee, right, and they're looking into this issue of welcoming unvaccinated employees back into the office, I think you can hold them accountable for that message in that clearly they're looking into this, as they should be, quite frankly. If you are an unvaccinated employee and somehow you are being punished, and you just said it yourself, Antonella, you're on unpaid leave and want to go back to work, I have an issue with this, Antonella, quite frankly. I don't think employees should be being placed on unpaid leave as a result of their vaccination status. Listen, it depends on your industry. It depends on what particular job you're doing. Again, the devil is always in the details, but employers can be doing a lot to keep employees working and not putting them on unpaid leave. Some employees, and I would say a good number of employees, actually have the right to treat their unpaid leave as a termination and get severance. Antonella, certainly I would hold them to account with respect to their comments. I think they're at least signaling that they're making or they're taking a step in the right direction. If you haven't already, Antonella, and you're on unpaid leave as a result of not being vaccinated, give us a call. Let's have a chat about your matter. Again, you may have some options here. You may have some rights. It also depends on whether you're a unionized employee or not. If you're a unionized employee, I hate to say it, but your options are probably very limited. It's ultimately your union that's going to decide what to do with you in consultation with your employer. If you're a non-unionized employee, and again, you haven't spoken to us already, give us a call. Let's have a chat about your situation. You might have some options. We have fielded a ton of questions about vaccination policies. Actually, I was just speaking with a very nice gentleman this morning about an employer's vaccination policy. And again, I'm coming to you here from an employment lawyer who practices employment law in Ontario. I'm actually surprised to see that these very strict vaccination policies are still in play in May of 2020, or 2022 rather, given all of the restrictions that have loosened in the public. Our chief medical officer having relaxed all of the restrictions. Most employees that we speak to are able to somehow be accommodated in their work, either by working from home or having different work schedules. Perhaps rapid testing is a measure that we've seen for all employees, vaccinated and unvaccinated, that will ensure a healthy and safe work environment. I mean, there's a ton of things that employers can be doing to make sure that unvaccinated employees are continuing to work, continuing to be productive employees within the company. Simply, strictly implementing a vaccination policy that requires unvaccinated employees to be terminated or placing them on unpaid leave, I think is unreasonable. And so for anybody who's still struggling with a vaccination policy in the workplace, again, and particularly if you're a non-unionized employee, don't be shy to reach out, give us a call, visit the website, email us. Let's have a chat about your matter. Again, you have options, you have rights as an employee in the workplace. All right, Helen asks, can you please tell us the pros and cons of a retaliation case through Human Rights Tribunal or Supreme Court? Which is better? Helen, the Supreme Court is going to be a difficult endeavor. You have to go through multiple stages of our justice system, starting typically with the Superior Court of Justice, at least in Ontario, and then moving your way through the appeal courts and ultimately the Supreme Court, if leave is granted. Ultimately, I don't think that that's a likely scenario. And so perhaps if you're dealing with, as you mentioned, a retaliation case, and what you might mean by that is you were somehow punished in your employment as a result of, well, if it's a human rights tribunal, it would have to be a discriminatory ground. So if you feel like you were retaliated against because of a disability or because of any other protected human rights ground, so that could be age or religion or gender or nationality or race, if you feel that you have been punished in your employment on any one of those grounds, certainly the Human Rights Tribunal is the way to go. And certainly a claim through the Human Rights Tribunal might be viable. Again, Helen, if you haven't received, and I appreciate that this is advice that you hear often from me, it's the honest truth. If you haven't spoken with an employment lawyer yet, Helen, and I see that you're in British Columbia, we have an office in Vancouver. You don't necessarily physically need to attend the office. We can have a phone consultation or a video conference consultation. Give us a call, reach out to us. Let's have a chat. You may have multiple options here. Let's discuss your best option. It may very well be, as you suggested, the Human Rights Tribunal, if you are dealing with a discriminatory ground. Again, disability, age, religion, gender, nationality, etc. If you have a severance claim, perhaps the court system may be the better likely is the better option to go. And Helen, you mentioned it's bullying from a manager in a follow-up message here. That may very well be what we call, again, I referenced it earlier with respect to Megan's question, a constructive dismissal. If you can prove that your manager has harassed and bullied you, we may be able to extricate you from the work environment and obtain severance and maybe even additional damages for the way in which you've been treated. So again, before you file any complaint with the Human Rights Tribunal, before you do anything, Helen, make sure you get legal advice from one of our BC employment lawyers. Fortunately, I only practice in Ontario. Otherwise, I would have loved to chat with you. But again, reach out to us. Someone from our Vancouver office will be able to assist. All right, Melinda with the follow-up question. I'll give you the follow-up, Melinda. Is an employer allowed to put you on leave if you were in the process of going on disability leave already? I guess the responding question, Melinda, would be, well, what kind of leave are they putting you on? Are they putting you on a medical leave because they suspected you were medically unable to work? An employer oftentimes is not allowed to put an employee on any particular leave unless they have the contractual right to do so. So, a leave could be a temporary layoff, is oftentimes what leaves are called. If you're referring to a medical leave, listen, employer forcing an employee to take a medical leave, that might be discrimination in and of itself. We need to know more about the situation, Melinda, and perhaps it's worth a conversation off air. That sounds odd to me. Again, employers usually aren't allowed to put employees on leave as a matter of right. Again, if you're a unionized employee, Melinda, you might want to speak to your union about this or your union representative about it. If you're a non-unionized employee, give us a call, send us an email. Let's have a chat about it. AJ asks, if an ROE has code N, brackets leave of absence, does that qualify for EI? Again, if we're talking, AJ, about a medical leave of absence, you would be eligible in Ontario, at least, for, and I think actually this is generally true across Canada, for employment insurance sickness benefits. That's actually what they're called. And yes, that is a form of employment insurance. However, it's for, a limited period of time. I believe it's a 15-week EI benefit for medical leaves of absence. If you're talking, AJ, about another form of leave, again, we need to know exactly the circumstances of the situation. If it's some sort of layoff period or whatnot, you'd still qualify for EI most likely. But as a medical leave, you don't qualify for regular EI, you qualify for employment insurance or EI sickness benefits. All right, we're going to start wrapping up here, guys. I will answer the last couple of questions and then call it a day. Keith asks, can you settle your wrongful termination case at arbitration? I have a status conference pending arbitration. What does that mean? Keith, it depends on whether you're a unionized or non-unionized employee. Usually in the unionized context, we are talking about arbitrations. Most unionized grievances are resolved by way of an arbitration if they cannot settle between the union and the employer. If you are a non-unionized employee, Keith, and you have actually started a legal action, an actual litigation for wrongful dismissal, well, a status conference might mean that you're actually very close to a trial and the court wants to know whether you're ready for trial or not. That's what a status conference is in the legal system, in the court system. But again, that doesn't jive with your reference to arbitration. So again, if you're a unionized employee, speak to your union about this, speak to your union rep about this, Keith. They should be able to answer your question. If you're a non-unionized employee and you're going through the litigation process or through an arbitration, a status conference might simply mean that they are looking, that the arbitrator or the judge is looking to know the status of the case and kind of where you are at in the proceeding. That is what I suspect it would be. Last question for the day. In the nick of time, Rocket asks, my current work schedule is 9:30 to 4:30. My employer wants to change those hours from 8 to 4 temporarily. Can they do that? And is that a constructive dismissal? Great question, Rocket. My contract doesn't say they can change. Rocket, if it is a temporary measure, and if the change is 8 to 4:30 instead of 9:30 to 4:30, so it's effectively an extra hour and a half of work on a daily basis for a temporary basis, my off-the-cuff opinion would be it's likely not a constructive dismissal. I don't think that's a significant enough change for it to warrant, severance effectively or a claim for constructive dismissal. Now, again, as I mentioned to Megan, as I mentioned to everyone else over the course of of this Q&A. The devil is always in the details. If there are any more changes, Rocket, being implemented, if you're being asked to do different job duties, if other things are changing, then you may very well then cross the threshold into a constructive dismissal. Before you accept the change, before you say anything to your employer, give us a call. Let's have a chat in private about the situation, and you'll actually be able to get tailored employment law advice given your situation. That is it for today, everyone. Thank you so much for the question. All excellent, excellent questions. Thank you again for those. Until next time, I believe we'll have another Q&A coming up tomorrow, Friday, May 6th. Until then, everyone, have a great rest of your day and an excellent weekend as well. We'll see you back here next time. Take care, everyone.